Hi, everybody. This is Fresh Source TV. I'm back with the last portion of Tereasa Martins' lawsuit that she filed against Crown Plaza Hotel and its associates. We stopped on page 21 the other day and we were on count four. And so count four reads as such: breach of contract, third party beneficiary defendant, capital security. 93. Plaintiffs decedent realleges and reasserts all previously enumerated paragraphs as though fully set forth herein. 94. At all times pertinent herein, defendant Capital Security entered into a contract with the Crown Plaza defendant as the exclusive provider of security services. 95. At all times pertinent herein, upon all the information and belief pursuant to Illinois law, defendant Capital Security owed a contractual duty to provide security services and maintain a safe premises for the benefit of the business invitees, guests, and plaintiffs, decedent Kanika Jenkins in particular, at the Crown Plaza Defendants Hotel. 96. At all times pertinent herein, defendant Capital Security intended to confer a benefit upon a non-party, namely the business invitees, guests, and patrons of the Crown Plaza Defendants Hotel, to prevent unreasonable risks and dangers on their premises. 97. At all times pertinent herein, defendant security capital defendant Capital Security contractually assumed a duty to protect the premises, the general public, its business invitees, guests, and plaintiff, decedent Kanika Jenkins in particular, on the premises of the Crown Plaza Defendants Hotel. 98. At all times pertinent, relevant hereto, defendant Capital Security had a duty to act when they were put on notice of a disturbance in the hotel room where plaintiff decedent Kanika Jenkins was a guest. 99. At all times pertinent, relevant hereto, defendant Capital Security had a duty to act when their agents and/or employees responded to a hotel room where they smelled strong intoxicants. 100. At all times pertinent, relevant hereto, defendant Capital Security had a duty to act when the agents and/or employees were aware of dozens of people were, were present in a hotel room limited to only four guests. 101. At all times pertinent, relevant hereto, defendant Capital Security had a duty to act when their agents and/or employees were aware of criminal activity occurring at the Crown Plaza Defendant Hotel. 102. At all times pertinent, relevant hereto, defendant Capital Security had a duty to act when the agents and/or employees were notified that a smoke detector had been disabled in the subject hotel room. 103. Defendant Capital Security was negligent and/or grossly negligent and responsible for: A. Failing to secure an area otherwise inherently dangerous. B. Failing to timely review security cameras when undertaking the duty to do so. C. Failing to hire, manage, supervise, and train employees and/or agents who were competent to deal with missing persons in a reasonable manner. D. Failing to hire, manage, supervise, and train employees and/or agents who were properly trained not to negligently disregard dangers to the general public. E. Failing to hire, manage, supervise, and train employees and/or agents who were competent. F. Failing to hire security personnel who were competent and capable of acting reasonably under the circumstance. G. Failing to adopt proper procedures and policies for their employees and/or agents. H. Failing to enforce existing policies and procedures to prevent the conduct described herein and are failing to promulgate sufficient policies to prevent the occurrence alleged herein. I. Failing to properly and adequately train its agents and our employees with relation to safety procedures and other acts of negligence and gross negligence and reckless conduct to be observed. 104. Okay, so from what I'm reading, this is where they get into calling out what they claim Crown Plaza and its associates didn't do in order to um, find Kanika in a timely manner and in order to ultimately save her life. This is the didn't do area, so to speak. So 104. Had employees and our agents, Capital Security, properly intervened in a timely fashion when they were put on notice of a disturbance in the hotel room where plaintiff decedent Kanika Jenkins was a guest, she would not have been able to become disoriented, distressed, or lost. 105. Had employees and or agents of defendant Capital Security properly intervened in a timely fashion when they smelled strong intoxicants coming from the subject's room, plaintiff decedent Kanika Jenkins would not have been able to become disoriented, distressed, or lost, which would have prevented her death. 106. Had employees and or agents of defendant Capital Security properly intervened in a timely fashion when they realized that the subject hotel room was not used for its intended purposes and that dozens of people were present in a room limited to 4 guests, plaintiff decedent Kanika Jenkins would not have been able to become disoriented, distressed, or lost, which would have prevented her death. 107. Had employees or agents of defendant Capital Security properly intervened in a timely fashion when they were put on notice that criminal activity was occurring in the subject hotel room, they would have broke apart the party and then plaintiff decedent would have not been able to become disoriented, distressed, and lost, which would have prevented her death. 108. Had employees or agents of defendant Capital Security properly intervened in a timely fashion when they were put on notice that a smoke detector had been disabled in the subject hotel room, they would have evacuated the room and the plaintiff decedent would not have been able to become disoriented, distressed, and lost, which would have prevented her death. Oh, I don't, oh my God. My energy level just went up to 100. 109. As a direct and approximate result of the negligence of defendant Capital Security, plaintiff decedent Kanika Jenkins was seriously, painfully, and permanently hurt and injured as her body shut down and she froze to death. 110. As a direct and proximate result of the above described actions, plaintiff decedents Kanika Jenkins and her estate suffered damages including but not limited to conscious, physical pain and suffering and death. B. Severe emotional injuries. C. Mental anguish. D. Mortification and humiliation. E. Embarrassment and denial of social pleasures. F. Economic loss, including wages. G. Medical expenses, past, present, and future. H. Exemplary damages. I. Punitive damages. J. Attorney fees and costs. K. Loss of love, society, and companionship. L. Reasonable funeral and burial expenses. M. Loss of gifts, gratitude, and other items of economic value. And N. All other damages are liable by law. 11. 111. Under Illinois law, defendant capital security is vicariously liable under the doctrine of respondent superior for all negligent acts committed by their employees and or agents when acting within the course and scope of their employment. Therefore, plaintiff respectfully requests that this honorable court enter a judgment in favor of plaintiff and against the defendants in excess of $50 million, exclusive of cost and interest and attorney fees. We're on count 5. Doctrine of respondent superior, vicariously vicarious liability and or contractor liability. Crown Plaza defendants. 112. Plaintiff decedent realleges and reasserts all previously enumerated paragraphs as though fully set forth herein. 113. Upon all information and belief, on September 9th, 2017, agents and or employees of Crown Plaza defendants were notified of plaintiff decedent's disappearance. 114. Upon all information and belief, on September 9th, 2017, agents and or employees of the Crown Plaza defendants undertook the duty to aid in the search for plaintiff decedent Kanika Jenkins. 105. At all times relevant hereto, employees and or agents of the Crown Plaza defendants were acting within the course and scope of their employment with the Crown Plaza defendants when they undertook the duty to aid in the search and recovery of plaintiff's decedent Kanika Jenkins. 116. At all times relevant hereto, Crown Plaza defendants contracted with defendant Capital Security to provide security service to the Crown Plaza Defendants Hotel. 117. Information and belief. Crown Plaza defendants contracted with defendant Caddyshack Restaurant to provide food services to the Crown Plaza Defendants Hotel. 118. At all times relevant hereto and pursuant to Illinois law, defendant Capital Security owed a duty to act with ordinary care for the safety and security of the public and specifically to the plaintiff decedent Kanika Jenkins. 119. At all times relevant hereto, the Crown Plaza defendants and defendant Capital Security owed the plaintiff's decedent Kanika Jenkins those duties to set forth in this complaint and negligently and or grossly negligently breached the same as set forth here in this complaint. 120. As a direct and proximate cause of all defendants' negligent and or grossly negligent actions, plaintiff decedent Kanika Jenkins and her estate suffered damages included but not limited to those set forth in this complaint. 121. Under Illinois law, the Crown Plaza defendants are vicariously liable under the doctrine of respondent superior for all negligent and or grossly negligent acts committed by its employees and or agents when acting within the course and scope of their employment. 122. Under Illinois law, the Crown Plaza defendants are responsible for defendants' Capital Security and Caddyshack restaurants negligence and are gross negligence by virtue of contractor liability. Wherefore, plaintiff respectfully requests that this honorable court enter a judgment in favor of plaintiff and against the defendants in excess of $50 million, exclusive of costs, interest, and attorney fees. And there's the date. It's signed December 11th, 2022. Respectfully submitted by uh, Ryan Timoney, Esquire. And these are the attorneys that are on the case. And it says it's Jack Bean, Matthew M. Peterson, Esquire, Ryan P. Timoney, Esquire, Beam Legal Team, LLC. And they give the address, the firm number. And that's it, guys. We have completed and gone over their entire claim as to what they think should have been done in the search and rescue uh, for Kanika Jenkins. I'm going to give a little commentary on this. Um, these are just my thoughts as I was reading this. Um, I see that this crew of attorneys, they went through this and they investigated on their own very in-depthly. They went to this whole entire case scenario with a fine-tooth comb. As you can see, there are 100 they made claims up to 122, okay? Not to count the alphabets they included. So, I mean, at this point, all we do is wait and see. But I'm almost certain that even with a jury trial, Miss Tereasa Martin will be granted a significant, substantial amount of money. Now, we know money, you can't put a dollar sign on a life, but the negligence displayed in this case, we all watched the videos. We saw how what was happening We saw how they diverted, how they chose not to look for Kanika Jenkins. They chose not to take this missing persons report seriously. Now, what I can honestly say from reading the case files and now going through all of this, because this is my first time reading it in its entirety. I just knew bits and pieces of it, even though it's been on my computer for years. Um, at this point, I don't feel like my gut is telling me, my gut feeling. I may be wrong. This is just my opinion. But at this point, I really don't feel like Rosemount Public Safety uh, Police Department um, played any part in this. And if they did, it was very, very, very minute. Um, what I feel like happened was is what most of us have been saying over the course of the years, is that when Kanika left that room, along the way to that freezer, she was snatched up by somebody. She was snatched up. What they did to her, we don't know. We do not know. That's something we don't know. Um, I also feel that she didn't die in that freezer. Or she may have died in the freezer, but I believe she was placed in that freezer. That's what I want to say. I believe she was definitely placed in that freezer. I remember in the beginning, and I'm going to have to ask friends who have more of the footage, uh, the freezer footage. There was an issue when Kanika walked through that freezer, uh, not the freezer where they found her at, but the other kitchen area, about how the layout, the actual layout of that kitchen, because of the way she walked, it looked like she was making a U-turn. Okay. The freezer where the big black fan is, where everybody thought they saw a man in blue on you know, in that kitchen, but I never saw that. All I saw was a cart with something hanging on it that was blue. Um, I truly believe, because of the few little skips in the time, and when you really, really think about the situation, and you actually, I challenge each and every one of you to do this, even if it's for a few minutes. Set you a timer, 2 minutes or a minute, and see how far or how much you can do within those 30, those 60 seconds. You can do a lot in 60 seconds. Believe it or not, a lot can be done in 60 seconds. And I believe, like, those few minutes that are missing on certain portions of the video is where something is actually happening. And that's the missing pieces. to this puzzle that we've been trying to put together for 5 years, almost 5 years. And that's just my thoughts, guys. Thank you guys and have a great evening. Good night.